let me issue this case as I'm not a lawyer. And in the Sedinam clue, you know, made them a kind
okay.
As at Friday, no my kind, as at Thursday, my kind 30 pages. Friday, maybe I love it from a breakdown, I'm a kind 48 pages. My team could do if you bear one, and I'm a team kind of cram a da bear 1 hour been a media ban. So, but me who a summary by Professor Kwekwaza, and I think that it makes perfect sense based on what I usually say to have read.
Okay.
That does not mean that, you know, lawyers, you can give them 2 provisions of the Constitution. The interpretations will vary. So that is his interpretation, and that is an interpretation I usually say to agree, having read the judgment myself.
Okay.
I don't know what
yes.
So let me issue that caveat so that someone will not come and say that way, man, media. And I don't want to take credit for somebody's work. It's not my right. But Abraham Madam Sedinam he was acquitted and discharged, you know. And acquitted and discharged basically, and say she cannot be charged for the same offense.
Okay.
Yes, sir. If you being left in a double jeopardy. Yes, sir. It's the law of natural justice.
That's right.
You cannot trial the same person on the same charges twice. Into no, the court near me say acquitted me shame.
Okay.
Say be a discharge, say be a there be charge it the defense and cobra. But to acquit and discharge me you go so be some viewer me shame.
Okay.
I will explain why.
Okay.
Na 2 attorney once a man for blame Godfredam so be true statement me blame way. I don't think me view say u blame mienu na eyeye. I also explain with document why me dream say. You see there be am jana me kase me say oral cases no. Oye attorney general deputy obetimi akasa ne okasa. But at the end of the day, the person to give the verdict to weigh the evidence you presented and what the accused person has equally presented will be the court.
Okay.
Mamu example, me YouTube channel the critical analysis. And I'm a coca say Hanan Okaya Judge Ruli what kind letter no? Said in Qatar any problem on Kwabuchiri.
That's right.
That's what the judge said. What do you want the Attorney General to do? But Qatar Nani it will go UK. The judge granted.
Judge Amano Quine.
And you know, say, oh, bufu, na kase bia, Attorney General Godfredam, and I say, Ayenia, maybe you say to them against a far fetched.
Okay.
Because they will present a case. The case is for someone to decide. As a sheriff, who came to me. Say you never say come here to never, but this decision in him. If you won't listen and blame say you Juma, I don't take that decision. Kuku could take that decision.
Yes.
So the one who takes the final decision, in my view, should be the one you question.
That's it. And it's very important say Nippon a court system.
Exactly.
And until I can say Abaya Jai Sedinam.
Yes. But I mean blame one because none will be.
Okay. You can be. That's right.
Bibi say ni kete akoka akọ the jam afka say suko no man awo ka say kete na say because I knew because this is senior is that make us me surprise and me yemra
that be
me surprise na be man said na tamaklu why can't anope cram this bit me you know because no stay of execution appeal court and fair ruling
yeah
me ba to what here entina ya dwen de tire bia me ka say ya dwen kire mamu another example then this miracle you are no closer to Dennis Miracle than me you did but me can say prosecuting why. Because the then is called quarter. I want you to the brief fact of the case.
Sure.
Say the then is at the end 5.2. You could say 55. Deputy Attorney General Crasso, no more bank card a boss.
Sir.
By a quarter. And I'm pretum shirt here black. I'm pretum shirt here white. Yes, I'm pretum here rasta. Yes, I'm pretum here tuntum. A quarter. Brief fact of the case. The one you be one.
When you can't send me.
Yes. And when I net me say, and I will say, and you are buying many penny say we and I fact no.
Jackrami and you some court.
Exactly. And you can prosecute to be and yes, then is called jail and answer so much cojela. Me you go say to now they do the special cojela. And obey you could then I'm gonna make cojela. Into how we how there's no bearing on my life.
That's all.
But so we person who no prena court and only that I know the positives of it. When the matter goes to court, when I charge you also have opportunity to
defend yourself.
Evidence.
That's right.
But you see, Sedinam when I was reflecting on it this dawn, I said, "Me yati OSP I say in the Kenofria Tamata."
Oh, okay.
I can't me true to mama. Say me trust. I said, "Me yati always be taxes bi an person ye kenofrata bro so person yezu so on tiase wo mra no me ya tiase and let's not forget the wound to me trial when Judge Audrey Kokuvite said that wound to me na no masem bi my more example say me renfi ona ama Henry Okumzo nkoye galamsey debi make so nkoye reclamation o ma ni sika debi uso nkodua kube be so 10-15 years ni ati kube ni aton kube sika ti reclamation enti oma a reason but deducing from the reason in the view of the judge the trial judge, it doesn't make sense now let's go to Professor Azanse and me I think the international for blame era gov Dominic Kayen and I letter on the band sometimes I throw letter so I'm careful TSM will say the attention of the Attorney General has been drawn to the decision of the Court of Appeal acquitting the former master. Now, okay, so your attention has been drawn. You will say to two. A German so you should know me here. It is Okuku se Kuka because my attention has been drawn to her. But when you won't mean Kasa because you are party to the case.
Yes.
It's I think so almost some phrasing of letter no a problematic.
Yeah, Mr.
Yes, let's go to the substance of Sedinam.
Okay.
First issue ni about Tampa microfinance. Must look more mobesia 500,000.
Okay.
No this kind of coin no about Tampa for say interest na mo de to so no esolodo. Prosecution case na me bon the top factor. Ana say na so muntimi jom fam sika emra me. Ana kon prosecution de go free so no ko twen no bato na total. To mo de sika na ma no. Ana ba Tampa chairman say, "Madam, sika de ma head ye me serew. Me hia letter bi e kire say." Why den? Waji sika no. According to prosecution, omukobu no letter no obatampo for de wo ho iyoko de no ayira. But sasika na madam said that time on 5 occasions that letter come obatampa say monfa interest ya den na sika waje. Wadi in oguso letter say we hear interest wo ho. That is one.
Okay.
The second case in here sensitization bi ye twa abo 1.8 million 1.7 million dollars man no ekowie no 1.7 million cedis ekowie ase no na o ma spend 1.8 million cedis na 10 regions then 16 regions I'm so just about 3 regions Accra Brown half I think voter region nya kan o manye and also charge tenu sika no misappropriation unse ba we mu dia ye kan no TV on one bro for sophisticated misappropriation and a second one is a cantamanto fire victims on 579 million. What's happening to me? 800,000 Ghana cedis.
579,800.
800. They just talk market 2015. Siko fen kom woman. Yesu di sikano. Again, okoto cars because na nebuo no esusun. Ebu onso amfa public procurement authority. Unsa okoto aban ade bia na so de ko PPA no muhwem. Ewe ekroje bibia no se onso anya saade no. Again, let's get say be treat your man who mobile phone your koto say mobile phone near 50 cedis or 70 cedis. Saade ni nyina account on the year. The court no, this is basically what the court said on all the matters. Let me just summarize for you. Court on the case said charge sheet near the man no is defective. Now let me explain the charge sheet. Unse the court was basically saying say a charge na the boss says okay account be conspiracy to steal. What ingredients are you basing on to say that there was a conspiracy to steal? You can't conspiracy say many am prechuma prechum microphone e de koduma e benya bu sa Eugene okay me kura me hu say CCTV no mu dum ne be 10 nti ebo 10 na hyiamase woni emetumi you no conspiracy me no wako nakra na
yakoye kanana
say charge sheet no na sa boni Sedinam tamaklo dia ode money laundering to no so ode stealing to no so ode causing financial loss to no so ode willfully causing financial loss to no so akeka ni nyina bo mekoye 78 charges no e to masuma enyeyi charges is defective again no hold this say eba burden of proof so what can Sedinam koto bibi only authorization from public procurement authority the onus lies on the prosecution and the one making the allegation to prove say no new authority no and shift bad and then cause Sedinam was say yes we new authority into one authority and as a new authority so the burden of proof per the appeals court at all material times was on the prosecution to prove that she didn't have the authorization now yanko enema 7 na mebo man yanko ba bia so the court found serious evidential proof about Tampa. The original acknowledgement letter was not produced. The document tendered was a copy obtained from Obatampa. No corresponding Maslow copy was produced. Evidence, even though the reference number on the letter suggested that Maslow should have retained a copy. Also, a copy. Let it be our date.
Yes.
Numbers.
That's right.
Obatampa will let any bomb call Maslow. Let any be. Now, the Maslow official who testified has not seen an official Maslow copy against which the document could be compared. The chairman of Obatampa who claimed that he had exchanged WhatsApp messages with Sedinam concerning the refund, those messages were not produced. Obatampa said, "Oh, minister can come in Sedinam bonkomo, mame, me dia bo uska no kan asun. Ka son fa WhatsApp message mom de or want me fa message in nya den." But let's not forget that at the appeals court, they will not sit over new evidence.
Okay.
They will not allow you to bring in new evidence.
That's
except
right.
in extremely exceptional case.
Right.
They were only assessing the facts as presented and ruled on at the lower court, which is the high court.
That's right.
It means a question by one is a senior. The court when they said now funny because they couldn't prove receipts. Because now Ogusu demand this kind of from Obatampa, which means now on knees can in the view of the appeals court, yeah, 500,000 anyway.
Anyway. Obatampa ho anase we he
said now. So I think that even though she's been acquitted and discharged, and the only route is going to a Supreme
there are still questions to be answered.
There are still questions, and maybe some civil matters must be considered in this matter. That is maybe view.
Sure.
Because there's no establishment of the whereabouts of the 500,000. And the 500,000 increase 5 billion. And we come back 10 years ago.
And easy.
See, but what you
sure.
TFN2. Now, the issue about sensitization. Or say the prosecution's case was that the program neither did not occur or occurred only on a very limited scale. The court held that the prosecution did not prove beyond reasonable doubt that Sedinam stole the money. The prosecution did not call the relevant regional officers or beneficiaries who could give direct evidence about whether the program took place or not. Instead, the trial judge expected Sedinam to prove that the funds had been properly used. The court held that this again wrongfully transferred the prosecution's burden to the accused. It's burden of proof now, or say. In case 10 regional chairman, form chairman, directors of master of operation voter for musica buy program no na benefit on number one man fresh microphone would blame the man said in that temakula. But you see, there's a phrase in here. Or say the prosecution did not prove beyond reasonable doubt. In criminal trial, you must prove beyond reasonable doubt. That's a sensitization.
So
again, almost also can say countermand of market fire. No. Almost say one prosecution witness admitted that enquiries had established that the funds had been distributed to the victims. Another witness had confirmed this to him, although the information was omitted from the report tendered in evidence. The court held that this admission struck out the foundation of the stealing charge. If the funds had been distributed to the intended victim, the allegation of dishonest appropriation could not be sustained. The conviction and sentencing related to the countermand funds were therefore some say Stekano microphone could do dances. Oh, you should share microphone can be a tweet.
Stekamo
e could do dances a tweet. This is nipa no say yes car.
Na that dey assembly.
Sika ye tweet the same to be here. But the court also is not telling us. Yes, you can pay to some people.
Yes.
One prosecution
so who can
testify who were paid
that's
and
right.
how much they received. Now, say, unfortunately, at the appeals court, they are not at liberty
to do certain things.
Yeah. Now, I say, what happened to the money laundering conviction? Very important. Say they were set aside. The allegations stealing offenses were the underlining or predicate offense. Say. How do I explain supporting the money laundering members charges? In simple terms, the prosecution first had to prove that the money was the process of an unlawful entity. Before someone can launder money or steal money, it must be from a certain unlawful act. If that unlawful act is not proven, the person cannot launder or steal the money.
Okay.
And this is basically the summary. Court no boni nyina to go here. That's basically the summary.
Not just say you can money. You can say you can money laundering. Now say it me chirema ehun say baby ani panya sika ni free no. Enya kwampa so. Na wantimi anchirem say enya kwampa so a untimi nkasa nipa no why money laundering. Why money laundering? And again no money laundering an element is bia sika na kwampa so. But the one who transfers can ni ma bia wodi ye ne baby a wode fefa no. And so emfa mramu. And untimi fa ba kwa so no so money laundering. Na court no ba cast no cast na mo cast say na tam ko to ya mo charge no ho. MPP are buying the can threaten a bit. Okay.
they renegotiated and paid.
Okay.
They will not sign contract. So that's also my issue. If you're saying that someone paid, the contract is a binding contract. They renegotiated and paid. But who signed the contract?
Signed it?
So I think that yes, she's been acquitted and discharged. That is the law. I'm not a lawyer.
Yeah.
But I think that commonsensically, they've raised some questions in my view, and I think that you and I have debated on that matter. But let me skip. Attorney General so call Supreme Court akosiki review of the matter. And now High Court transfer for the stay of execution. It means you need free prison. Yeah. I'm fat. Almost on conclave 2 hours on by decision to me. But the reason why I can't say, I think that the blame on Godfrey Yabo Adame and Attorney General is that the case was handed over to Dominic Ayene. When they were defended, in fact, when you read the entire 43 pages, only time. When you read the entire 43 pages, he mostly argued the same point Godfrey Adame argued.
Okay, because the same fact, no general so
the same fact. And in fact, what's here the body language of the Attorney General when he did the government accountability? You know, CRC report.
Yes.
Can't 2 minutes.
Yes.
Look, I'll say, even the court in the US,
yes,
when they were presented with the evidence, believed in us and extradited Sedinam. So he is unhappy with the appeals court, and he had, in fact, I think that posture shows that he's very, very unhappy.
Sure.
Maybe that's my view. You're entitled to disagree.
Sure.
But the reason I think it's not fair to blame them is something. You see, when they wrote, after the appeal came to the attention and everything, that Attorney General had to write. And senior, my kind court document, I think that that's one of the most strongly worded statements that Attorney General be.
That's right.
Standing by the fact,
decisions,
the conviction of a former Attorney General.
Okay.
It's me can't go for that response here be or see o ma me no na wo you me aso obo kind Attorney General na ma a bit uncomfortable kakra because I don't see where the Attorney General did the state wrong, and I'll read it for you.
Okay.
Because my country is chef and me view and what the facts say.
Sir.
Now let's try there. Or say this is Attorney General speaking. Already see preliminary objection. Whether it's the state attorney or whatever, they prosecute on behalf of the Attorney General. To get it is clear.
Yeah.
Even now the OSP, ya catch this one baby
it's Attorney General
of the Attorney General. Okay. Now say my laws, the antecedents to this case point to the fact that Sedinam, make appellant to Sedinam.
Okay.
Herein was tried and convicted in absentia. She was sentenced to 10 years, but remained a fugitive till because I said na Ghanaian, Mumubiza Montiasian, where Attorney General Neka say remains a fugitive from justice, and as such has not served even a day of the sentence imposed on her by a court of competent jurisdiction.
Yeah.
Our criminal justice system has been marked by a persistent effort to balance the coercive power of the state with the fundamental rights of the individual. Or see, Ghana, yes, state no so. In Article 99, clear say. Those say the state has unfettered access to power, resources, but when you be balance the human rights and then the powers of the state. Yes, I did so. Mammy, I can't once a court. And my say you try no.
Yeah.
Oh, Jane. 1 year cry, 10 years man on 7 years.
Yes.
Of course, you say. However, a specific procedural dilemma arises when an accused person, having been duly notified of criminal proceedings, chooses to abscond.
That's right.
Attorney General say.
That's right.
Adiana mo be ye no. Muni hu say. Adiya ye be man no. Ya bona man ye se charge ye dia bonini.
Yes.
But we decided to be Jane.
Proceedings crash shall say for about 3 years.
That's Attorney General speaking.
That's right.
Leading to a trial and subsequent conviction in absentia. The legitimate question that arises is whether such an individual, now a fugitive from justice, retains the right to utilize the appellate machinery to challenge their conviction while remaining outside the reach of the law. I tell you the point and say,
that's right.
Legitimately, the court with the so will be on journey from system now a person punishment system a born a man yes or born ya wedding system na man the council on some kind of side of store journey that's it's fair for that person to come back and use that system to vindicate a position. That's Attorney General speaking.
That's right.
It goes further to say that before we proceed to discuss the above raised issue, it is pertinent to put this appellant's case in a perspective and state the fugitive appellant is not challenging the procedural steps which were taken in commencing the trial in absentia as not meeting the legal threshold for proceedings in absentia. What she is challenging is the outcome of the said trial. It goes further to say that, my lords, it is right that the right to appeal in Ghana is a creature of statute underpinned by constitutional guarantees. It provides a mechanism for the correction of legal and factual errors made by lower courts. For a person convicted in absentia, understanding the statutory framework is the first step in determining whether an appeal can be mounted that is not just filed but effectively pursued and heard by the appellate body. Into this page, the Attorney General basically goes to the Court Act of 1993, Act 459, to say that, appeal there, because the lower court they try from so. There should be a bigger court who will sit on the matter, and it ends at the Supreme Court, where the appeal process will evaluate the facts and make sure that there is no error. And see, said Natama appeal, the Mramukram and Quine, and more appeal no boss and cruna. Or say, under the Court Act, the right to appeal is generally granted to any person who is aggrieved by a decision. This broad language suggests that the status of the person, that is whether they are in custody or fugitive, does not inherently extinguish the existence of the say any panejane. See a channel. Always my appeal or build a point about the act provides that an appeal may be on a matter of law, a matter of fact, or a mix of law or fact. Say appeal there, law, ebia mrano, court here, ebia fact no, when you ebia try a measure of the law and the fact. The appeal there but what can or say, however, after establishing that some platoon court ne butiana, a mrama no kwany. So at 459 to go to an appellate court. Or say, however, the Courts Act also grants the appellate court the power to regulate their own proceedings and to make orders that are necessary for the administration of justice. This includes the power to strike out appeals that are considered an abuse of the court process. This power, granted the judiciary and the common law fugitive disentitlement doctrine, put together means that once Act 459 grants a right to appeal, the court may refuse to exercise its jurisdiction if the appellant is in active defiance of the law. This creates a situation where the right exists in theory but may be procedurally barred in practice. Also, yes, Ghana manama can say appeal, but who court now better appeal no so. If there's a defiance of law, that's right. You can use that to throw out the appeal.
That's right.
Because there's a defiance of law, and the judiciary must be the custodians and protector of the law.
That's right.
This is Godfred Dominic Attorney General speaking. It goes further to say that it is important to share light on the fugitive disentitlement doctrine at this point. That's what fugitive disentitlement doctrine or say the fugitive disentitlement doctrine is an equitable doctrine which prevents an evasive party from obtaining standing in a court which authority it evaded. Sorry. Or say okuku se kwa frame no one pretum se BBSC
me se me ma
ana ofre office Eugene bebo nkro me na mkobo wo charge am pretum mu nipa wona ne ye kwa no ahye da dum microphone o madwuma ntam ne fact nye ana okuku fr ampre Eugene o kani obra me ma wo ye hwan me ma ana wa ama ana Attorney General ka se fugitive disentitlement doctrine say one man okuku se kwa bu echa se wa ma dia ma suspend o 1 year without pay e men sire fa bio afi na wo be ka se okuku no Eugene kan oboa ana Attorney General ka se sa dia no ma ho kwan a enye yie o say
because
it's a doctrine which prevents an evasive the process evasive party from obtaining standing in a court which authority it evaded.
Your friend many more ama ye bo ebubo no dey o say me afa na me ba defend me ho
and Attorney General say yes enye now goes to say that it limits a person's ability to appeal as long as he or she remains a fugitive. According to the doctrine, an appellate court may dismiss an appeal when the person seeking the relief is a fugitive. It is important to state that Article 11 of the 1992 Constitution, the laws of Ghana include the common law as well as the rules of law generally known as the doctrine of Young Counsel Senator Mahama on his own appeal. She was arrested.
Yes.
and or citing authorities any other or citing authorities now no kind. But you see, to conclude for you why I believe the blame is not fair. The Hanokra the Yamakama and West Nanos Elfomu or citing authorities we no say. It is right that under our law, a convict who wishes to initiate an appeal must comply with specific procedural requirements, the most important of which is the filing of a notice of appeal. According to the rules, of course, a notice of appeal in a criminal case must typically be filed within 30 days of the date of the judgment or sentence. The act of filing a notice of appeal is a clerical or administrative task which notifies the court and the prosecution that the conviction is being challenged. At this stage, the physical presence of the appellant is not strictly required. A lawyer acting under instructions, even if the instructions were given before the client has gone, can technically sign and file the necessary paperwork. It must, however, be stated that filing the notice of the appeal is not synonymous with mounting the appeal. It is a submission that the latter involves the substantive hearing of the case, where the presence of an appellant becomes necessary, and as such, a fugitive status possesses a significant value to the process. It goes further to say that, my lord, the jurisdiction of the appeals court to hear an appeal, such as the instant case, is subject to several conditions precedents, some of which are found in statute and others in judicial policy. One of the primary limitations is the requirement that the appellant must not be in contempt of the very court system they are seeking to use. Or say, one of the condition precedents is that the court you are coming under to vindicate your right, you must not be in contempt of that court. That
is I'm presuming
education. See what I say?
That's right.
So that's Attorney General speaking. So how do you blame him? I don't see where you need to blame him. Now it goes further to say that one of the primary limitations is the requirement that the appellant must not be in contempt of the very court system they are seeking to use. It is our submission that the appellant who fled the jurisdiction during the trial and who has avoided serving the prison sentence imposed by a trial court could be viewed as being in the state of constructive contempt. And we urge this court to view her as such. She is in what? Constructive contempt. We further submit that the effrontery of the appellant to mount this appeal when she has conveniently decided not to surrender to the jurisdiction of the court is something that should not be countenanced by this honorable court, as the conduct of the appellant is an affront to the sanctity and integrity of the court.
No shit.
Also said in that time the new wasmanka the effrontery can you say? Say court a wabuna nimtia se nya kukuduro sa bad judicial system na wabuya nimtia no bepe reprieve. It goes further to say that it is trying that once a competent court of law issues an order, it is expected to be obeyed, except only when the order has been set aside. Now the concluding statement, for me, then I'll leave it to your judge.
Okay.
It is a submission that Sedinam's acting defiance of being at large is a flagrant disregard of the judgment and orders of the court that sentence, and as such, this honorable court should not entertain this appeal, as the conduct of the appellant is an affront to the administration of justice. This is appeal court. It may mean who be person blame Godfred Dami and say Dominic Ayene. At the end of the day, as I've always said when I do this analysis, it is a court who will decide.
And I think the court also will take it away seriously, because we know Akwa to say where's now Okano. I know she papa.
In fact, we know who. Who's our panelist number? We know you have to forward. It's a 43 page. I can forward it to you. If you read it in good conscience, I don't know how you blame either Godfred. In fact, in challenging the grounds of the appeal, the current Attorney General relied on all the facts of Godfred Dame. He relied on the fact. Okay. In fact, for me, these preliminary objections that they raise make common sense. Okay. That there's a process. There's a camera no so sit here. Yes. There's a process that called you that you have questions to answer. This is basically the fugitive disentitlement doctrine.
Yes.
You disrespected that process, and according to the Attorney General, he used fugitive, he used abscond, he used fled, not even serving a day until you are arrested. How do you come back to that same process to vindicate your position when you and in fact, the Attorney General said it here that she was duly notified of what? The charges. This is it. Or say, however, a specific procedural dilemma arises when an accused person, having been duly notified of criminal proceedings,
chooses to abscond, leading to a trial and subsequent conviction.
Exactly.
In absentia.
This is the Attorney General said, you were duly notified. So if indeed you knew these facts were not as it was being presented, why did you run? And that's the Attorney General speaking.
That's right.
So for me, I think that the greatest of respect, I have my issues with the court. But I always say that
that's right.
Some way, somehow, they are supposed to be the ones to do what?
It is in their bosom.
The matter. It is in their bosom.
That's right.
So how did? But me, you just said, you see, you know what I was surprised about? It's the 3-0 decision.
Anyway, unanimous.
I was very surprised.
So
but for me, I think that what Attorney General done and the posture. It seems as if he's very, very upset by it. Because for him to quote, and you see, what is important for people not to know is that when Sedinam was extradited, the US statement was very instructive. Now, Jeff, I don't know, say, let me get it for you, because you see, I tell you, say, one of the things my criminal lectures will tell me that you need to do a content analysis of things, and it helps. I'm trying to get you what the court said, the US court said in the extradition of Sedinam. It was very, very important. So it tells you that it's not as if Godfrey Dam for say Godfrey Dam Godfrey Dam with the greatest of respect, the US court, the same court I'm believing in, so US is the cathedral of democracy. They say something there. I've sent it to Jeff will project it. But I make kind from for say justice has no borders. The US has extradited Sedinam to Ghana following a conviction on 70 plus corruption related charges, including embezzlement more than $6 million, equivalent in Ghanaian taxpayers' funds. This is our strong US Ghana law enforcement partnership in action, demonstrating a shared commitment to accountability. And the first extradition from the US to Ghana since 2009. In 17 years, a court in the US saw evidence, and based on the weight of the evidence, decided that for the first time in 17 years, they will extradite this woman to Ghana.
Yes.
So based on all this, I say I'm surprised. This is why I'm surprised.
Okay.
But that is one. How many minutes more?
Okay, but NC 3-0.
Okay. Now, the Attorney General press conference on the original, it was on the Constitutional Review Committee. President Mahama on the 19th of January, yes, when in the 12 days, and 8-member committee to do a constitutional review exercise. So they will go around the country, canvass the views of people, put it in a recommendation, so the government will also have a say. At the end of the day, the constitutional review is at the BS of the executive, no matter how you look at it. Yeah, Prof. Mills started the Fiajo committee, President Kufuor started with the Claberry committee, any Abenya H. Kwasi of CDD. Okay. Now, we share the full video, but I think that people will get a better perspective when they look at the entire document. It's a 68-page document. We take it and read it, it will help. So the committee, Professor H. Kwasi Prempeh, Dr. Reina, Akumpriga, Metidino Fencha, the former justice of the Supreme Court of Yadenia, Professor Kwame Kakari Charlotte, the former EC chair, the Dr. AC and San Alaji, Ibrahim, Dr. Gordon, Jokotomi 8. Now, the key ones are about Matatinano. So we just go to through some of them. Now, say, me, I don't know why even the Supreme Court is entertaining this matter on Article 66. It's two terms is two terms. Let nobody bring any Ghana.
Say consecutive.
Ghana, say two terms.
Sure.
Mahama we dewi oni baby
akọ. We two terms.
And one. Obi interpreting is anka oma. Ti yenje mfenso oni enya isa ade. Or say the committee recommends amendment of Article 66(1) to extend the duration of a president's term from 4 to 5 years. The committee also recommends an amendment to Article 1131 and 2 to extend the term of Parliament because it has to go
in tandem.
Concurrent, right? No, in tandem. In tandem is not concurrent. You know, presidential term na 4 years, they call 5 years. My view on this, I've struggled to give a view even on my channel. I think that I'm here to see a compelling reason.
Okay.
What you cannot do in 4 years, I doubt you can be able to do it in 5 years. That's my view. I'm here to see someone to
convince
me on the argument.
Okay.
I'm yet.
Yeah.
I don't know so convince me.
No. My grandmother even called me. Maybe Nana friend maybe say me say we are. And I'm say, hey, I was watching over 5 years no. And
people are saying that it will be it won't start from President Mahama. That's not how it happened. It won't start from President Mahama. It will be anybody after.
Yeah.
That's how it is. Laws do not take a retrospective effect.
Yeah.
He was elected based on this position. So if you amend it will not take a retrospective effect. Yes. Now they also say that the minimum age, once Article 62B, now 40 years. And a committee, the committee recommends amending Article 62B to reduce the minimum age of eligibility for election as president from 40 to 35. The current minimum age of 40, government position here, excludes qualified citizens from seeking the highest office on the basis of an arbitrary age threshold. Reducing the age to 30 years is consistent with the trend in modern democratic constitutions towards greater inclusivity. A citizen who is old enough to serve as a member of parliament should not be constitutionally barred from contesting for the president on account of age. The president, 40 or constitution currently, committee recommended 35. I buy as a 30. Because parliament, I think 18, right?
Yeah.
18.
Yeah.
21.
Okay,
21. So we better make a parliament. I question and say, yeah, why can't the person be president? That's the yardstick of it. So they brought it to 30. Then so you make chum. It's into me, but just for one. Now my head said, "Meet me at
the and you're bad."
And now, I said, "Bad." I said,
"And you're bad." And
you're bad. Be about them 50. I said, "The president ambition was when in the year." See him in the
tall order.
So I'm saying $1 million. So which Mama bear 50
billion be on your bad. And your problem.
You two to microphone again, Omoka said, Kenya.
Yeah.
I like the Kenyan system. I've forgotten the time, but they have a very defined timelines for presidential election petition.
Okay.
Now, the committee is saying that they should amend Article 63(2)(a) to provide that presidential election shall be held on such day in the first week of November. They say November, but the specific date, maybe it was 7 December, that day, EC will decide on that. Now, presidential election petition, Article 64. The first one in 2013, to August 29.
Yeah.
I call for most time, Mahama intimidate any major decision. Those things have a bit. When it comes to the economy, there's some kind of perceptions. There's some kind of believability. So when this idea na shaky, almost say no. Say your election results now. You have 14 days. To challenge the results. Then the Supreme Court must sit on the matter in 30 days. I think it's fantastic. And see there. See, everyone say they about November. Everyone saw the 27th November. You keep here 7 now.
Yes.
Meaning see a election roughly around 10. See the nana do 2-3 days. Everyone by 11 p.m. so we are worried. By easy on one end Juma say so cool.
Yes. Kenya dey now kind of 7 days.
7 days.
Yes. 7 days.
That's fantastic. Say Yaman say born the 10th frana. Between 10th to 24th, say 2 weeks to file the petition.
Okay.
Now Supreme Court to send a petition now. They have 30 days. So meaning that by the time they are swearing they are clear at the everywhere.
Sure.
And now when you are swearing president that there's an issue about the legitimacy, any major decisions there. I think it's fantastic. Yeah. One of the things that outrightly I support.
Okay.
And I also feel say November and also be because I had that transition, it's an accusation. You can say in your way. You can say when you say as a converted your cool. We say a catch the way, we say and country way, we say cry for and you see that position. I still hold that position. And media and young crying fault. I cry peduma.
Yeah.
Saka 1 hour crime will be free office no money.
That's right.
So the issue is not about Newton Taylor to every action. There's an opposite and equal reaction.
Yeah.
Before you look at the reaction, look at the action.
That's right.
Who initiated the employment procedure? That is the problem.
Okay.
Because I'm going to say a punish not in Kolana or no Nukunya Dumano. What I say? I choose it. So I say, Newton tell me I'm a science today. To every action that Okukuseku, or frame say, Massa, BBC, the BBA, but me from Marco San Cras.
Simple cry. I feel BBC is a
no Pedumano. As a day, are crabby or one who's social there's own crab bonnet and penny for bonnet.
That's right. That's
your generation is raising.
That's it.
It's the old generation failure. Yeah, feel.
That's it.
So that's it.
That's it.
That's just by the side. Now, conditions of service of the president. They say president will make your tax. They will make your tax. You told me to be. When you go,
what you say? La.
Nanze me call baby na mo airport. Now sorry, that current regional constituency organizers. Most of them
I would love it. Not say keeping say no international because it looks like comment want to infuse it. But say na yen ninkomo.
Senior obet ma correct. Who say constituency who say but do me sin ba.
No.
Say no dey.
Okay, let me
Dumbako. Who say current constituency organizers no. Abrechu mom no me NADMO directors me be most na youth organizers akọ why.
Yes.
Na ba ko frame the youth ebre. Me ntimi me true feed who dey one no den kaduma me 12 months and my. Na me frame pani bi ka do Eugene. Yen so dey my. Na say na say wo dey my. Ba na say ya party bi a we ye no. Amakra yo ko.
What you say?
So dey ampo. So then master come on there. Na president Mahama to do the person pay no di. I dey boy me.
David.
Amom yo ki.
Ma ka say
President Mahama bosom so o musambo send salary.
David.
O dey there.
Government architecture in a position ba kwa me view. Enye kwa man for pro MP. Enu answer me to kokobe na me twam ayo. My code.
And let me tell you one thing. You see, sometimes we pretend to be fighting corruption. Let me tell you, President in you may be Ohio. Scan the good Ghana must go Muneba. Let's not pretend.
Wow.
Oh, but that's the truth.
Wow.
I'm telling you the reality. Let me tell you.
A general perspective, no share.
You're a hypocrite.
Sure.
Politicians.
Now, are you doubting it?
What?
Yeah, who MPs who be on car boot? Election time who be on car boot? No, we have seen so many things.
I'm not blaming Mahama, so keep.
And that Mahama, you blame no. You blame the system.
Please, I'm telling you this. Me say, let's not pretend. The salary seminar.
No, but you see, senior friend, you see, the point is even making it that look at MPs for example.
Oh, what they know and fuck off from the body. It's a drop in
no, what I mean about that, look at their salary in the public.
Okay.
That's around 30,000. But Oman by your interviews now, quite year weekend now. It's kind of bob. So it tells you that I'm a senior man so can. That's why I've always believed that me is independent. Chairman Sani is that's one kind of correct.
Yeah.
One of the biggest ways to fight corruption is political party financing.
Wow.
The day we get that thing right, declare how you are getting this, like they do in America. You cannot bring, you cannot get it.
Yeah, time. Yeah, wabem.
Okay.
Man to be a sena, yeah, the 5,000 bread party. NDC. Man to be almost the 20,000 bread party.
That's right.
Mumusa party ni mi so many scanaway.
So no way.
Mumusa so many scanaway.
We are party in Redma. Party.
Why are we pretending?
Party in money making venture.
Political party finance. In fact, there's a provision for that. Senior Max Orakono, let me get that for you. There's a provision for that where now the presidential immunity. So no, sir. Now committee recommended says the president Mahama Teswa and the president Kufuor that we take a civil action against presidency. Say we the alien dominant. I'm saying the Mumungu. We want to be the president and the civil matter be the no matter. Again, I'm here say presidential term limit them aka. I don't say president minister MPs no so. I'm the court 300.
Yeah, I'm a couple.
Now say come about 200.
Now 24 year.
There's still an opportunity to add about
Maza,
about 14
you know where the problem is. I don't blame the EC, the current reading of the law. You see, Ezra gerrymandering. EC is supposed to create constitution based on certain requirements. If that requirement is met, a constitution like Bosomtre, it's not municipal, based on population. So maybe it's not them that create the constitution.
Anyway,
it's how the current law embodies them. Because for me, for example, how do Ghana have 300 MPs? Now let's not forget that the 300 MPs means that packs of office
yes.
But you know baby. Emrana and Kase easy. And creative constituencies living count.
Okay.
It is nowhere.
Okay.
What the law says, say, after census, review. the boundaries of the constituencies. You can review upwards or downwards.
Yeah.
When is it there be a review? And
I make us a population dynamics. For example, for you to be a municipal, I think when you get 120,000 and above, you're a municipal.
That one I agree. But there can boundaries, no. Let's take a municipal assembly.
Yeah.
And one more time, the two boundaries necessary and necessary chrono. It who is a population and was swarming no. Akosro do. What you do say Abia
you show some of them.
We are talking of
balance.
Oh, okay, Martinez here. If there be a just no for the Kuma, Abia as a boundary near Kwamo, and maybe a man wants a Kwamo. Administratively, no. Okay. What's sudden quite happens even in Cameroon. What's echo as Adena? There are some countries political homo baby, administrative homo baby.
Yes.
I think that those because 300 MPs there.
Too much.
And I only 300 MPs here can mean that our conversation about bigger parliament and
Saba.
Na se nipa 200 intimi nyamra ma 300
bitim
na mra ikro mu yi
nipa se parliament
omo nko parliament
mra yi
entino eno so ye ade a e buy and again dual citizenship you see this thing I have a very now if you're a dual citizen you can contest for any position but senior me the fundamental question that if you really want to serve your country why can't you relinquish a foreign citizenship to serve your country?
Okay.
That is one question.
Okay.
But the next question is also that you can't FDIs, you can't remittances,
foreign direct,
you do musika, you do investment. So why can't they contribute to decision making? That's the two arguments.
Yeah.
That if you indeed want to really serve your country, why can't you relinquish your citizenship?
Because you're not touching no.
Exactly. And also FDI for a year no so says you say for say you sikaba in you create businesses you sika be shim incident na you sika be shim dia mo beje you be say be pray to me be kan asemu bi
and dia mo say
there be but you no so no very
be sepanding koni na haban
interesting one aba again ba ko aba regulation of political party campaign.
Okay.
Committee now the main kind man.
Okay.
The committee recommends a new proposition in the chapter 7 of the constitution to establish an independent registry and regulator of political parties and campaigns. IRRPC. This committee would assume and expand the Electoral Commission's role in registering and regulating political parties with enhanced enforcement powers to monitor compliance and sanction violations. The committee further recommends that Parliament enact to amend legislation to control the cost of electioneering and political campaigns, including restrictions on campaign periods. You call election year 3 months a year campaign. Expenditure caps, disclosure requirements, and sanctions for the abuse of incumbency. What's the abuse of incumbency? For example, election, President Mahama on Kubi, but the President Mahama or Kobe, not the flight to campaign. How do you draw the lines? Is it campaign or is it government? As a seven
in a ruling government.
In a ruling government. People are accusing by me of that. But you cannot draw the dichotomy. Because in 2016, President Mahama was certainly it will bless state resources.
Let's not forget.
Yes. But they do maybe now helicopter people will bring that. But see, even in America, Donald Trump, I'm told that in a certain period, say we use Airbus one and you pay for it.
Okay.
So I think that was what the committee was thinking.
Official.
But the government also says that they say that the government accepts in principle the establishment of an independent body to register and regulate political parties. The government considers, however, that a political party regulatory commission it will pay regulator no government said they be doing from independent registry and regulator of political parties and campaigns to Political Parties Regulatory Commission is a more appropriate designation than the nomenclature of the registrar and regulators. The government accepts the recommendation to deepen internal party democracy under Article 55 by expanding the right to elect party executives and candidates to all members in good standing. Now, most of the Supreme Court ruling now will be Now, the government through this is also agreeing with the Supreme Court without necessarily doing a different statement.
Yes.
But the issue a caveat in Gusana political party none of them how we decide. Moje taxes, moje dues, munkoya samadi. Ezo be to be. Oforu krom ye 100,000. Na nipa ketobia ko se dem. Eyi my kwedu. Omaji 55. Dey na me inten o wa last year. Big man ko friend na bo so nya 10,000.
That's right.
Nipa 1,000. Anani obetua because on so for come no swami and I'm also winning candidate wa 10,000 he said it already
na we one dey amoya no no you know dey amoya no you see I don't want the dey amoya no na fin no person wo play ostrich it is a fact
ye nim kura mo na makoy primaries na
come on don't bring yourself
Baba Jamadi
motorbike na
Baba Jamadi obi na TV na moto
you na untu abi but yes UJ
obi o be katro ba bia so kwale so untu abi bi oboa
no when the better
me say brand me say me body and there's evidence that's what we say mama if na ehwe no no him tell brand kokoya no ye technique chain na
yes
so obi say unim Nienti asad na ye prevalent in Ashanti Media and other eastern region sa ebia o court voter region say. Some so we need so am primaries. Meto sire.
Yes.
Safe seat. It almost so 10,000 cry na won kire no. So that is the problem.
So go offend yes money vote buy inti and when uncle second term.
Na
House of Chiefs. Even House of Chiefs.
Na okay do say as regards to the regulation of campaign financing, the government does not accept a constitutional amendment. It's necessary for this purpose. Campaign financing regulation is a rapidly evolving field that requires the flexibility of ordinary legislation. Expenditure caps, disclosure threshold, and enforcement mechanism must be capable of adjustment as political and economic conditions change. Parliament can enact the requisite legislation using its residual constitutional and lawmaking powers. The proposed PPRC bill provides the appropriate legislative vehicle for this. It's a banner so the mrana then. But you see, conveniently, and if MPP was in power, they would do the same.
That's right.
You know why? Who's a conveniently? They agree. It's winning. Was say agree in principle.
Yes.
But I won't bet try and say you better say you better campaign say there. Because it evolve no bro from there.
Now what kind of friends say that be? What kind also?
Na so fin could be. Oh, could be no better kakra. And then you make it kakra. Abratum, the senior be call election. Okay, say we what we are no come say into the crack. No, as I trust no more about the tougher. The crack. As massa, what got try Russia yes because of the DMP be strategy. But the last one be my chief justice. I find this a bit confusing. The justice of the Supreme Court retired at 70. Now, the CLC recommends amending Article 1452 to provide that the Chief Justice shall hold the office for a single non-renewable term of 10 years or until the retirement age, which, however, occurs first. The government support the introduction of a fixed non-renewable term for the Chief Justice for the reasons acknowledged by the CLC. Now, my kind of CLC recommendation, they are saying that it's not a written rule, but for you to become a Chief Justice, you must be a Justice of the Supreme Court. They are saying that so we are 40 years, crying your Chief Justice, who did 10 years, automatically you retire.
Wow.
Me tear for let's catch you for so. And I will be busy saying to me 50 years. But when 10 years, can I go back to serve on the bench? And was a best IGP Dampare. He was not due for retirement.
Yes.
But will you go back to be a COP? It's a gray area.
Yes.
So I think that maybe we need to iron that because maybe taking that is Felic's view.
All right.
What I say?
Right.
Because we say 10 years. Meaning say you're just on the Supreme Court, who may be 50. It's your body is a Chief Justice or some 10 years we are.
That's right.
Can that person go back to the bench? That is interesting. Now, based on how
they retire on their salary. Yeah.
In terms of the benefits, only we to lose. She has nothing to lose.
Oh, baby, you also feel so by your Juma.
I'm going into private practice.
Now, who say Article 146 they implement it?
I'm sure. Eugene, I'm sure Omu introduce way because of the tokono issue. Because of when the age now, na nipa bebre be say retirement.
Yeah.
Into your mouth idea.
Yeah.
But senior, why can't you also get to the point? Say, I'm just sharing my own lawyer view. The arguments that people made was that Tokonu was there. I mean, 10 years late. But for Bonnie, 2008, Kwame 2005. To some it makes sense because in the law, for example, there is first seniority. In fact, me Jamadan look at Chokwa me say I will know no. You case ba senior for you mu je na be 4 na mgusu te ho. So 1 year the bar minimum one country means minimum says I am. Men am being a case in
your body over.
Senior and ballet create so if that is the case, maybe conventionally we can make it simple because before you be named as someone to go and serve in the chairs as on the bench of the Supreme Court, it means that you have some knowledge.
All right.
It's how they be a senior, you know? Because you see, let me give you a case. 146, you know, to become problematic.
Senior.
The years
no, maybe seniority at the bench. Seniority at the bench.
Yeah. Okay.
For example, Justice Foreman Committee net now. Get this scenario based on Article 1 for any pay. Except President Bonipa 5, 2 sitting justices of the Supreme Court, and 2 other people. They don't need to be MPs.
Right.
They were a lawyer also. I think there are 5 people. And about Puamadi. After Bafuboni, Puaman is the most senior. 2015. So imagine the case Justice Bafuboni, who is due for retirement in December, goes on retirement, and Puaman is named Chief Justice. What will be the narrative? Now we need to say so.
Yes.
You get it?
Yes.
So for me, for example, one of the amendments I should see in 146 say, current justice of the Supreme Court must not be part of the process when a petition is brought against a serving Chief Justice or a justice of the Supreme Court.
Okay.
Because the way the thing is, it may fall on you. And if you are part of the committee, to be deemed as if what you did on the committee to serve your personal interest.
Yeah.
So I think that's one of the things.
No more interest.
Anyway.
You see, for example, 146.
Human,
the last one I asked Justice Efiasewa Saribotre, what is infirmity? You must know what is misconduct. What is because incompetence, misconduct, infirmity. So all those are great. Now to court no recommend they said just so the Supreme Court 15. After the conversation started and the President Kufuor said they are overwhelmed with cases here and there. But when we are 150 years and I rap on, I listened to almost all of them on interviews here and there. It seems as if say just so the Supreme Court more colleagues.
Sure.
But we feel say as a lower court name you want somebody do can you say do
sure. So
and in fact in this report there's a 2 recommendations that they should separate the Supreme Court from interpretation, that traditional battle, and also seeking sitting on actual matters. Okay. That one also was rejected by the government.
Okay.
But I say 15 so they call 19. 18 justices, 1 Chief Justice. So 19 justices of the Supreme Court. Okay. So that's the summary.
Great. Eugene Yedasipi.